Okay. Um, are we done? Sorry, I see some chats. Put in presentation mode. Okay, so if we are done with the attendance QR code scanning, I will then move to the next stage, which is the introduction of today's topic, which are just some general pointers which I just used to chat with you guys on this. But as we all know, the construction industry in Malaysia, of course, is a very major industry, and it spans various types of renovation works, generally for private homes, to massive, of course, large projects, construction projects, whether be it for real estate development or housing development or office lots and commercial lots. Yeah. So construction contracts are generally entered into between the employer and contractor to carry out different types of works, which would involve different quantities of work and different supplies of materials. And of course, it ranges across a wide variety of things, which involves erection, refurbishing, repairing, maintaining, or demolition of buildings and structures. So when we talk about construction works, it's not just about building works, but it also involves demolition of building works in certain circumstances. So all of this, of course, needs to be regulated. And what we need usually is a form of contract, a particular contract which is binding between the employer and the main contractor. Separately, there may be contracts entered into between the main contractor and the subcontractor in certain situations. So ultimately, we are all governed by contracts, and the rights of parties, the duties, the obligations of each respective party are actually stipulated in the particular contract that you would be using. So when we speak of contracts, generally, one would think that in a construction contract, uh, parties are free to just get a lawyer to draft an agreement for them, and that will be the contract. But strictly speaking, this is not how the construction industry works, because what they want is some form of standardization in the construction industry. So what has been recommended over many years is the use of standard form contracts. And in Malaysia, the most popular standard form contract that is used is the PAM contract, which is the Persatuan Architect Malaysia uh, set of standard form contracts, which has developed into different types of standard form contracts. Because in 1998, they had a particular type of PAM contract. They then revised it into 2006, a further revision in 2010, and the most recent revision in 2018. So they have different types of different types of PAM contracts, which may be used for with quantities projects or without quantities projects ultimately. And they have a set of standardized clauses which are used very regularly by employers. Sometimes you are allowed to add in clauses or amend certain clauses, but it is really on a case-to-case basis. And it's not advisable unless really there's some prevailing reason for you to actually change the terms in the standard form contract. So this evening, I will be talking purely about the PAM contract, because like I said, there are other variations like the FIDIC contract, we have the NEC contracts, but these are less common and less popular in Malaysia. Now, before we go into the nitty-gritty sections of the PAM contract, let me just explain to you the common flow in the construction industry as to how do we procure a construction project. From an employer's perspective, you would, of course, first have to call for tender. But before you call for tender, you would have already had, in a situation of a design and build or a traditional contract, you would have already had your drawings, your designers, your architects have already done everything that needs to be done in terms of drawings. And someone now needs to build it. Someone needs to construct it. So what you do is you would then put out a tender informing people that, look, there is this particular job with these specifications that need to be done. I am hereby inviting you to place a tender, which I will then assess and decide who to award the particular job or task to. So that is stage one, which is tendering. Once a tender is put out, you would have commonly people submitting their tenders, which means bidding for the job. You would then, as the employer, assess the criteria that you have set for under your tendering criteria, and ultimately you would perhaps bring it up to your board as to why you want to elect a particular contractor. If your board approves that particular contractor, you will then move to the second stage, which is issuance of a letter of award, informing the contractor that, look, we have now chosen you to do the entire contract, and this is a letter of award stating down various important clauses, uh, which will then translate into other contractual documents, which one of it is the PAM contract itself, but there are other contractual documents that will all form the contract per se, that governs the relationship between the employer and the main contractor. So far, I hope you all understand it's just very general position. But what is a letter of award is the next point that I will be dealing with. So in many construction or development projects, an employer will usually invite contractors to submit their respective bids and offers towards a specific scope of work of the project. This could be for supply of goods or could be for rendering of works and services. Now, if the tender of a contractor is successful, the employer will notify the contractor of such success by a letter of award. So it is simply a letter which is to notify the successful contractor that he has been selected to perform the job. What is included in a letter of award is very important because this sets out the key terms and conditions which will be included in the formal contract between the employer and the successful contractor. So remember I said stage 2, which is the PAM contract itself. The letter of award is sort of stage 1. It's sort of telling you the main key terms and conditions that will all eventually form into a much larger, more detailed document known as the PAM contract and other supporting documents which it's to be read along with. Now, the significant clauses in a letter of award, as I've said, they're meant to contain key terms, and these are generally a set of key terms that I would recommend should be in a letter of award. Ultimately, it is up to an employer what you consider significant. It depends on a case-to-case basis. Different clauses may have different impacts, and you may want to add on more things to your letter of award. But these are ultimately, at least what you see on your screen, are 10 areas which actually must or should definitely have to be covered in the letter of award, because it's good practice to do so to avoid any confusion or any disputes later on. So the first is to state the scope of works. Yep, the scope of works is ultimately a brief set of description of what the works to be performed is. Second is the contract sum, a very important clause, obviously. Third is the mode of payment. This one is not so important, but it's always good to actually set this out in advance in the letter of award. The contract period, of course, this is extremely, extremely important. It basically indicates to the contractor how long he has, before he's supposed to commence the project on site, and how long he's expected to take to complete the project. Next is the contract agreement under which the contract will be governed. Here, usually we would have a simple one-liner statement or sentence in the letter of award saying that the contract agreement under which the contract will be governed would be, for example, the PAM contract 1996 or the PAM contract 2006, for example. Other documents forming part of the contract, you may state this. Requirement of performance bond or performance security. You do not need to state this in full, but you must at least state that there will be a requirement for a performance bond to be placed. Requirement to obtain necessary insurance policies. Who is to obtain these insurance policies? It should be stated in the letter of award. For example, if you want the contractor to take out certain insurance policies, then state it in the letter of award. Permitted areas of operations and access. This is also something that it depends ultimately on the type of project, but this is something, if you have other contractors working on site, for example, then you may consider this to be an important clause which should be in your letter of award, because you wouldn't want overlapping contractors working on the same area, for instance, in certain situations. Acceptance of the site ultimately is the final thing that you will also see in a letter of award. This is, of course, for the contractor's part. So these are all essentially main or significant clauses. There are ultimately more than this, which you may choose to use depending on the facts, as I've said earlier. Now, is a letter of award legally binding? Of course, this is a very important question because one would think that, I haven't signed any agreement yet. This is more just a intention to agree into an agreement. That is what is commonly argued by those lawyers, by people who think that the letter of award is not as significant as it's claimed to be. But the other side of the argument is that actually the letter of award is legally binding. And this is actually provided for by the contract itself, and or rather by the PAM contract itself, in particular clause 3.1 of the PAM contract 2006, for example, recognizes the terms in the letter of award and further provides that in the event there is any conflict or inconsistencies between the contract documents, the letter of award shall prevail over the contract documents, such as the articles of agreement, the conditions of contract, the contract drawings, the contract bills, and other documents. So this specifically when it comes to PAM contracts, you can see that it is a very important document, the letter of award. In fact, it goes on to say under clause 3.1 that where there is inconsistency, the letter of award will prevail. So if you say your contract sum is X ringgit in the letter of award, but in the PAM contract, suddenly it's Z ringgit, and that there's an apparent inconsistency over here. If this goes to dispute resolution, either by arbitration or court, in all likeliness, and in construction of clause 3.1, you will have an arbitrator or judge who will probably follow what is stated in the letter of award. So it is a very powerful document. The moment it has been signed and returned to the employer, the contractor is bound by whatever is stated in there, and he cannot later choose to say, I don't want to enter into the agreement. Once he signs and returns the letter of award, it means that he has accepted his contractual terms to a certain extent. This is just an example of a case, Stealth Infra Sendran Berhad against SR Elias bin Marjo, 2016 decision. Facts of the case are as follows. The plaintiff in this case had issued a letter of proposal to the defendant to propose a joint venture project development. Now, during a meeting, the defendant issued a letter of award to the plaintiff to develop the project. The plaintiff signed and placed its seal upon the agreement, signifying that it had accepted all the terms. Now, it was provided in the agreement that other terms and conditions shall be contained in a development rights agreement to be executed by both parties. So please bear in mind, development rights agreement here is it's a specific type of agreement. So moving on to the second point, pursuant to the agreement, which I'm talking about, which is the development rights agreement, the plaintiff solicitor then delivered to the defendant a copy of the draft development rights agreement. This is the stage 2, similar to how I'm talking about the PAM contract as stage 2 over here. Upon receiving the draft, the defendant issued a revocation letter stating that the agreement was terminated. The plaintiff, of course, did not agree with this termination and insisted that the agreement must be executed because you have already signed on the letter of award. So as a result of that, the plaintiff sued the defendant, claiming that there is already a legally binding and enforceable contract because of the issuance of the letter of award, which was accepted and signed. So how did the court decide is the question. So issue before the court was whether a binding agreement was formed or not as a result of the letter of award. The second bullet point on your screen is what the High Court found, which is that there was an offer and acceptance of the letter of award, and that there was free consent of the parties because all terms of the agreement were agreed upon as contained in the letter of award. The plaintiff did perform consideration, and this is important because there must be some consideration performed. Otherwise, the letter of award would be of no use. But the plaintiff did perform consideration as there was promised by the plaintiff to develop the property under the letter of award and to make the deposit payment upon the execution of the development rights agreement and a specified number of condominiums. In the consideration, the defendant, who is the contractor, agreed to assign the development rights to the plaintiff and granting the plaintiff a power of attorney in order to perform the development rights. So you see, there is a loss to the contractor if, for example, the termination was allowed, because both parties have given due consideration to each other to enter into stage 2. And therefore, it has to be, for all intents and purposes, recognized as a valid and enforceable document, which is sort of a mini contract in the form of the letter of award. So in this case, of course, ultimately they found that the letter of award was not a conditional contract, as it was clear that the terms and conditions to be finalized in the development rights agreement was but a term to be fulfilled and not a condition of which the performance of the agreement was contingent upon. But based on the evidence, the letter of award was a legally binding agreement between the plaintiff and the defendant. Now we will move into the more important clauses in the main document, which is the PAM contract itself. So remember, once the letter of award has been signed and returned, you would then move into the second stage, which is actually finalizing your contractual documents. I apologize. So PAM contracts, what are they and how do they operate? Of course, they're a very large, I think close to 38 or 40 clauses in total under normal ordinary PAM contract. So we will not be able to deal with all the provisions under the PAM contract. Today, we will only specify and deal with very specific provisions, which I will come to very shortly. So what is a PAM contract? As I've mentioned already in the beginning, this is basically a standard form of building contract prepared by the Pertubuhan Architect Malaysia, and it is used very commonly in Malaysia. Why PAM contracts? Why people use it? As I've also mentioned earlier, irrespective of cost and complexity, every project that is something that to deal with more than 10 or 20 stories usually should have the usage of a standard form contracts, because it, like I said, sets out obligations and liabilities and duties of parties in a very fair manner. Allocation of risk, for example, is also very fairly done as to how risk would pass over from the employer or the developer to the contractor, at what stages this risk would be passed over, and so on and so forth. So it is really, more than anything, it is used to ensure that there is equal footing by both sides, and that is what the PAM contract ultimately aims to do. It doesn't want to give too much power to the employer or the developer. At the same time, it doesn't want to give too much power to the contractor. It's meant to be a level playing field, which means both sides of the coin have their respective positions that can be taken legally based on the contract. Now, what is included in a PAM contract? We have already seen what is to be included in a letter of award. But a PAM contract, for example, what is to be included in it? So today I'm going to talk about PAM contract 2006 in particular. And this is usually what is included in the PAM contract. The 10 things you see there are the 10 important things that I have actually taken out from the PAM contract. There are more than this, of course, but these are ultimately 10 very crucial provisions under the PAM contract itself. The first is, what are the type of works that is to be executed by the contractor? Second, the sum which is to be paid to the contractor for his performance of the works. You would notice a lot of this overlap with terms in the letter of award, and hence it is always important that there is no inconsistency in your letter of award in compared to the contract itself. Third, the extent of the contractor's liability for design. This is important, of course, because it goes to the liability of the contractor in the event there is a defect or a default, a defect in design, for example. The extent of the contractor's liability for defective works. So remember, this is slightly different. One is for design in the event the contractor has actually designed the project. Second is for defective works, where he may not have designed the works, but he has performed the works with inferior quality, for example. Fifth is the procedure for variation in works. How do you vary works in certain situations where the employer may want to add certain scope of works or decrease certain scope of works? How do you go about it? It is all covered under the provisions under the PAM contract. Sixth, the procedure for payment to the contractor. Seventh, the circumstances in which the contractor is entitled. Sorry, I've lost my mouse. Yeah, the circumstances in which the contractor is entitled to be paid additional sums for variations in the works and or disturbance to the progress of the work. So this is essentially your extension of time arguments, when he's entitled to apply for extension of time because there's been disturbance to his progress of works, or where he's entitled to ask for additional sums of monies because there's been his scope of work has been widened. The eighth point, which is liabilities with respect to insurance, very, very important. That will be in your PAM contract. The ninth point, the circumstances in which either party may determine the contract either on default of the other party or in other events. This is, of course, the most important, I would say, because it ultimately deals with your rights to terminate a party. So it is, and tenth is, of course, with regards to settlement of the disputes, which means in the event that dispute arises, how do we go about settling the dispute, either through arbitration? How do we go through the phases in the office at top management to try and resolve the dispute first before we go into the dispute phase itself? So all of this is regulated by the contract itself. So it makes life a lot easier for the participants who sign onto a PAM contract, which is usually the employer and the main contractor. As you have seen, the list above is not exhaustive. There's a lot more that is included in a PAM contract, and you will find this in any of the PAM contracts that you usually use. Today, I will be talking about clause 15, which is to deal with practical completion and defects liability. It's a very important clause, of course, because it is the stage where the contractor says that I have now done my part, and it also means that the risk element on the contractor technically shifts to a little bit, because there's still a defect liability period which the contractor would be responsible for. But ultimately, it is a very powerful stage of the construction phase, because it means the contractor has now practically completed the job, and he has got, a certain period of time to perhaps rectify defects and so on, which I will come to and deal with in the essence of how clause 15 works. But before that, what is completion? So one of the problems often encountered, in practice, is for parties to ascertain whether the works under the contract are completed. And the reason is because in most contracts, the important milestone is either not defined, or even if it's defined, it is not very properly defined. So the term completion has been given, of course, a very strict interpretation in this very famous English case of Babcock Energy and Lodge Stuyvesant, which is a case that has been used in Malaysia for many years now. But ultimately, this is what the case says, that a completion of a contract means the discharge of all contractual obligations, including the liability for payment of damages for breach of a primary obligation. Now, this interpretation has changed somewhere along the way, and now we call it practical completion, because when we say completion, it means full completion, which isn't very fair, because we are not talking about full completion. There's no way the contractor would have been able to fully complete the project, because there may still be minor defects, there may still be minor problems that may arise. So therefore, the word that they now use is practical completion. Okay, which means it is practically completed, or rather it has been completed to a certain extent where it is as good as completed, but there may still be certain things which require little touch-ups, for example. So Chow Kok Fong in Malaysia has defined practical completion like this. It does mean that the works have reached a state of readiness for use or occupation by the owner, with the exception of trivial omissions or defects. This is precisely what I said just a moment ago. This is, of course, worded in a much more exclusive manner, but it essentially states that readiness for use or occupation, with exception of trivial omissions or defects. This state of completion would thus allow for the completion of minor outstanding works and rectification of defects which do not detract from the enjoyment or utility of the facility by the owner. Practical or substantial completion should be distinguished from the expression final completion. So this is important, because final completion means a totally different thing, uh, in which I have said also in the slide. You would see the final completion is basically described to a state when all patent defects related to the completed works have been satisfactorily remedied and the works have received the appropriate statutory clearances. Just give me, yeah, okay. So clause 15.1, what does clause 15.1 of the PAM contract state? Now, clause 15.1 states this: the works can be contractually regarded as practically completed if and only if, firstly, the architect is of the opinion that the employer can have full use of the works for their intended purposes, although there may be works and defects of a minor nature still to be executed. This is under clause 15.1a. Secondly, works can be contractually regarded as practically completed if the contractor has given to the architect a written undertaking to make good and to complete such works and defects within a reasonable time specified by the architect. This is also under clause 15.1a, I believe. And the third point is where the works are to be regarded as practically completed if other requirements expressly stated in the contract documents as a prerequisite for the issuance of the certificate of practical completion have been complied with. This is provided for under clause 15.1b. So you have now seen these words, first time these words surfacing, certificate of practical completion, but I'm sure all of you know the significance of it. It is basically the point where you are saying it is the document that is issued by the architect, which is a very important document because only he can issue the certificate of practical completion. So clause 15.1 further empowers the architect to be the final arbiter as to whether the works are practically completed or not. This is what I just mentioned. But the use of the phrase in the clause 15.1a and b is the words used is in the opinion of the architect, which basically means that the architect is a very powerful man because he makes the decision. It's a subjective decision in his making. He has to decide whether or not it is practically completed, but he must, of course, follow the requirements under the PAM contract itself for the assessment of whether or not it is practically completed or not practically completed. And this is what is provided for in 15.1a and b. So I wouldn't say that he has got an unfettered discretion, meaning he can simply decide to say this one is practically completed or this one is not practically completed. He has to, whatever he makes, whatever decision he makes ultimately has to be dependent on the contract in and clause 15.1, whether or not it is deemed practically completed or not. So we will come to that right now. There are three scenarios over here that I would like to share with you. The first scenario, which is the clear-cut, clean scenario, the employer can have full use of the works for their intended purposes per se and no more, meaning there are no outstanding works, no patent defects, and there are no other preconditions in the contract that the contractor has to comply with. This is usually the rare situation where there are absolutely no problems whatsoever. Then yes, of course, clear case, CPC is issued by the architect without any issues because the employer has got full use of the works for their intended purposes and there are no more outstanding works. There are no further defects. And therefore, that is scenario number one, the very ideal, perfect scenario. Scenario two, the employer can have full use of the works for their intended purposes, but there remains outstanding works and patent defects of a minor nature yet to be attended to. And also save for the absence of other preconditions in the contract that the contractor needs to comply with. So you can see here, second scenario is where the most common scenario, which is where actually the employer can have full access of the full use of the works for their intended purposes, which means he has the right to enjoy it. He's already able to go in, but there is little things, little minor defects that need to be attended to, and there are some other preconditions in the contract which the contractor has to comply with. In this situation, in a scenario like this, you would still issue a certificate of practical completion. As you would see in the second point, the architect has to specify a reasonable time for the contractor to make good and complete such works and defects, and the contractor thereafter has to give a written undertaking to the architect. So ultimately what happens over here is architect tells the contractor, you have to make good certain defects within a certain amount of days, and the contractor would usually write back to say or give an undertaking to agree that I am willing to do this. If those things can be agreed upon, then yes, you would be issued a certificate of practical completion as well by the architect. The third scenario, which is the slightly more extreme scenario, is where the employer can have full use of the works for their intended purposes, but there are still not only outstanding works and patent works to be attended to. Please remember, I put here outstanding works and patent works. The word minor is not used here, but also preconditions in the contract that the contractor has to comply with. So in this type of situation, the architect is only obliged to issue the CPC, Certificate of Practical Completion, when the contractor has satisfactorily complied with the preconditions in the contract. In addition to completing any outstanding works and making good of any patent defects of a minor nature specified by the architect. So these are ultimately the three scenarios in which CPCs are most commonly issued by the architect. So clause 15.2 is the notification clause. So who notifies when a contract, or rather when it reaches a stage of practical completion? The duty is actually upon the contractor to notify the architect, and it is then the duty of the architect to assess the contractor's notification and decide whether or not he wants to issue the certificate of practical completion. So that is the stage of certification. So under clause 15.2, the contractor notifies the architect on the achievement of the milestone of practical completion. Prima facie, this connotes that the architect, prima facie meaning on the face of it, this means that the architect is not obliged to act unless and until the contractor gives the prescribed written notice. So although for all intents and purposes, he can act on his own volition and waive the mandatory notification requirement. So generally speaking, the contractor must notify the architect that he has already reached a milestone, because otherwise the architect wouldn't know that you have reached this milestone. So it is always important that the contractor takes the first step. But like I said over in here, it doesn't mean that you are now barred from doing it. The architect can still, on his own accord, on his own volition, if he knows that the contract is finished, he can also issue the certificate of practical completion. But it's always better if the contractor notifies the architect, because then nobody loses out any time that way. Now, so accordingly, the issuance of CPC can be deferred indefinitely should the contractor fail to give notice. So this is the danger. If the contractor doesn't give notice and the architect also doesn't do anything about it, then the contractor is the one who stands to lose out, because if there is no notice, then there is really no CPC to be considered by the architect. So it would seriously impact the date of practical completion, because it would be delayed on the failure on the part of the contractor to give the prescribed notice. So there would inevitably be delays that would come out of this. The architect under clause 15 also has then got a certain period of days to reply to the notice, or the contractor's milestone achievement, so-called. He has got only a 14-day period to respond to the contractors, and he has to decide on two things. If he's of the opinion the works are not practically completed under clause 15.1, then he must formally reject the practical completion, and he must provide reasons for the rejection. This is important. The rejection must be communicated to the contractor and also copied to the nominated subcontractors. Of course, the second stage is not so much the no problem stage, rather, where the works are deemed to be practically completed, then there is no issue. The architect would issue the certificate of completion if he believes all milestones have been achieved. And this, again, similarly, copies would be extended to the employer and also the nominated subcontractor. So everybody is aware of the issuance of the CPC. The moment architect makes a decision, everybody comes to know about it. The clause 15.2 further has got these clauses here: date of practical completion, where no such works and defects present or existing. Okay, clause 15.2b subs Roman 2 states, mandates the date of practical completion to be the date of receipt of the contractor's written notice. So bear in mind, it is the date of receipt of the contractor's written notice. So if the contractor issues something on the 1st of April, and 13 days later or 14 days later, the architect approves it and issues the certificate of practical completion, for the purposes of the date, it would be considered the 1st of April as the date when the CPC was issued. For outstanding work and defects of a minor nature, clause 15.2b, subsection 1 prescribes the date of practical completion to be the date of receipt by the architect of the contractor's written undertaking under clause 15.1a to make good the defects and complete the works in question. So this is the second stage, yeah? Remember, the first one is where there's no works or defects that are existent, then it would immediately be from when contractor gave notice. But if there are works or defects of a minor nature which exist, then the architect would, like I said, issue something known as giving them notice to make good their defects, and the date for which practical completion would be considered would be the day the contractor replies back to tell the architect that I undertake to make good all the defects that you have identified. So that would be the date. So I hope this is clear, the difference between how the date of practical completion differs in situations where there are no defects as opposed to situations where there are minor defects. Now, contractor's obligation to return possession of the site back to the employer. Under clause 15.2, the contractor is required to return possession of site and accordingly it's licensed to occupy the site for the purposes of carrying out the works on the contract immediately after the issuance of the CPC. So this is where I was talking about the transfer of risk. Yeah, there's not, so the risk goes away from the contractor per se, because he's now no longer in charge of the site. And the certificate of practical completion simply means that now you are in charge of the site, employer, and I am no longer the person who should be responsible for things that are going on the site. Essentially, it's a transfer of risk. So the implication is, of course, very important, because if there's any delay in issuance of the CPC, it will accordingly also affect the return of the site or the possession of the site to the employer. And of course, this has got its own set of contractual and legal ramifications. There are three main remedies, essentially, that are given to the employer should the contractor fail to comply with his undertaking. They are on your screen, and I will deal with the first one on your left. The employer may grant the contractor additional time to comply with his said undertaking. So this is the straightforward under clause 15.3a. I give you more time to complete with your undertaking. Because sometimes the contractor may say, I can make good the defects within 28 days or so on, but you come 28 days, the contractor hasn't completed the defects. What do you do as an employer? Sometimes it's not in your best interest to actually just start launching into a dispute with the contractor. So you may want to actually exercise your rights under 15.3a and give him additional time to comply with his undertaking. Second situation would be where the employer may employ others to undertake the outstanding works under the letter of undertaking and set off all costs incurred, including any loss or expense under clause 30.4. Clause 30.4 I won't deal with today, but clause 30.4 is the provision under the PAM contract which deals with your rights to set off. So second situation is, for example, as you can see, is a little bit more serious. It is where the employer is basically not satisfied with the way in which the contractor has performed his remedial works. He then engages a third party to come in to perform the works, and whatever charges he's been charged for, I just set it off against incurred as loss and expense that I've suffered, which means I reduce the monies that I owe to the contractor ultimately. So, and the third situation is where the employer may accept to leave all or any such outstanding works and defects in the works and set off an appropriate amount for the same under clause 30.4. This again is the most extreme situation, not advisable to use, although clause 15.3c allows you to do it. You only do it and you use it very, very sparingly, because ultimately you are telling the contractor, look, your works are defective, and I am assessing that your defects are valued at, say, 100,000 ringgit. However, I'm not going to actually do the work, or I'm not going to bring in a third-party contractor to do the work. So it is a little bit more serious, because you're actually not really incurring any loss. You're just telling them that these are all defective things, and I'm valuing the sum to be at a particular ringgit assessment. Now, let me elaborate on the first point here a little bit, which is regards to the employer granting contractor additional time. I've already spoken about it earlier, but if you look at the the fourth bullet point, yeah, one of the main matters to be considered by the architect and the employer is the contractor's conduct during the period of the letters of undertaking. If the contractor has shown, for example, he's diligently attending to the list of outstanding works and defects, and he's willing and is able to complete the remainder of the works, if you just provide me with additional time, then it would be incumbent for this remedy to be exercised, meaning you should exercise it, because if you don't exercise it, it's really for the developer's own loss rather, and it will also not look very good if this goes to court yes, I agree, it is discretionary, but ultimately the conduct of the other side also must be taken into account. So if you have a good contractor who's really trying his best to do those works, then perhaps maybe you shouldn't go into the next stage, which is what I'm going to talk about. This is the second stage, which is the most common one, where the employer, so presumably this option only comes into play when the employer is of the opinion that the remaining remedies under clause 15.3 are not feasible or desirable. In exercising this remedy, the employer and architect have to be mindful that the third party of the fact that third party action, though appearing to be very attractive, is in practice fraught with a whole range of procedural and contractual difficulties. Hence, it should be implemented only as a last resort measure. These are my own views, and I feel that you don't do this, like I said, unless it is absolutely and entirely necessary. So you must always exercise this with due caution. Yeah, this alternative has to be exercised. It's not stated when such an alternative is to be exercised, but it should be within a reasonable period of the lapse of the time specified in the letter of undertaking. Otherwise, the employer may not be able to effectively claim any loss or expense incurred in the intervening period between the lapse of the initial period and the engagement of the third parties. So don't jump the gun as an employer. Don't give them 14 days or 28 days to rectify the defects. And on the 29th day, because one little defect has not been rectified, you terminate them and get in a new contractor to come in to do those works. That wouldn't be a very prudent way of managing the issue at hand. Now, the employer may not accept to leave all or any outstanding works and defects and set off an appropriate amount for the same under clause 30.4. So this is where the employer accepts that all the outstanding works that are to be done, never mind, no need to do. But what I'm going to do is I will deduct these monies. So this is where I will talk about the second bullet point. Although seemingly innocuous in its express form, the instant remedy is rather problematic in practice. And this is the reason why. When establishing its financial impact on the parties, it is common practice that for such items to be subject to a diminution in value, exercisable under the valuation formula of an omission variation. However, clause 15.3c subjects this to the set of procedures under clause 30.4. Now, bearing in mind the likely difficulties to be counted in its exact implementation, it is submitted that 2 or 3 remedies prescribed that of the 3 remedies prescribed under clause 15.3, this instant option will be the least commonly exercised. Because remember, there is a very serious task at hand over here, which is the diminution in value. We do not know what is the value of the so-called defects because you didn't get a third party to come in to do it. So it's a much more serious thing when you take or exercise your options under this particular 15.3c. Do it very cautiously and very sparingly and make sure you get the advice, not of lawyers, because lawyers' advice is not very important over here, but more importantly of a third party assessor, a contractor, to say that this value of works are not properly and have not been properly completed. These defects have not been properly completed and it's valued at 80,000 ringgit, for example. So it is really an exercise of more industry people than the lawyer itself. Now, clause 15.3, which is the contractor's failure to comply with the undertaking. So remember just now we mentioned where the employer, or rather the architect, issues something to them, telling them to make good defects. Yes. When the architect does that, the contractor is to issue an undertaking to agree to make good those defects. But what happens when the contractor fails to comply with the undertaking? Now, this is provided for under clause 15.3. It does not expressly permit the employer to undertake the outstanding works and defects departmentally and set off the cost incurred against the contractor. The phrase "do any of the following" also does not permit the employer to any exhaustion of the 3 remedies. They have to be exclusively and alternatively exercised. Furthermore, the phrase "the employer may, without prejudice to any other rights and remedies which he may possess under the contract," limits such rights and remedies exclusively to those under contract and excludes by implication his common law rights. Sorry. Reading clause 15.3, 30.4, and 34 together, you would note that adjudication under clause 30.4 is not applicable after the date of practical completion. Yeah, so if CPC has already been issued, then the contractor would not be able to set off the under clause 15.3 B or C. So this is how the contractors, how it works when the contractor fails to comply with the undertaking. Clause 15.4 deals with the schedule of defects. Once the certificate of practical completion has been issued by the architect, one of the consequences is that defect liability period will commence. So how has this been defined under the PAM contract? You will need to look at Article 7X, and it defines the term defects to mean defects, shrinkages, or other faults due to material or workmanship not in accordance with the contract and nominated contract, and a nominated contract, and are due to any faulty design, if any, undertaken by the contract and nominated subcontractor. So it's a wide definition over here, because when they say shrinkages, it could mean a lot of things, okay? And defects or other faults due to material or workmanship. They kept it very wide. So the extent of defects that are actually covered under Article 7X usually is, it will cover both types of latent and patent defects. Of course, only materials, workmanship, and design, if any, are the elements that are involved. Any elements that are beyond this will not be considered as a defect. Such defects extend also to those under the scope of responsibility of the nominated subcontractor. So remember, it is not just between employer and main contractor, but the nominated subcontractor would also have to be cautious and be wary of the definition of defects, because he would also be bound by it. Now, the defects have to be caused by the contractor or the nominated subcontractor. Of course, that goes without saying. The contractor shall not be liable for defects due to factors such as fair wear and tear, abuse or misuse by the employer, or if it's waived by the employer, and those that are out of time or statute barred. So that also, I think, is very, very obvious. Uh, Fair wear and tear is something which is very commonly argued to be defects, but please again always get a professional's assessment whether this is actually a defect or whether it's merely just a mere wear and tear. Because if it's a mere wear and tear, then you will not be able to actually claim that it is a type of defect. The use of the phrase shrinkages or other faults does not qualify the term defects. Okay, so when you see shrinkages or other faults, sometimes people think that, oh, it just means this is what they mean by defects. No, it doesn't mean that. It doesn't mean that defects equals to shrinkages. It actually means that defects equals to shrinkages and more other faults. Yep. Article 7Y defines defect liability period as the period stated in the appendix under clause 15.4. So this is the period, as I've mentioned, it triggers, or rather it is triggered the moment your certificate of practical completion is issued. This signifies a period prescribed in the appendix after the works are completed, during which the contractor is required to make good any defects at his own cost. The said period commences on the date when the works have been certified to be completed by the architect, i.e. a certificate of practical completion or certificate of partial completion or certificate of sectional completion. Different words are used, but ultimately they have the same meaning. Therefore, for a single contract, there may be a number of different defect liability periods that may be concurrent. The duration of each of this will depend on the respective entries made in the appendix to the contract. Now, when we talk about defects, how do we actually communicate this to the contractor? So first it is actually all on the architect. It is the architect's role and responsibility to do all of this under the contract, and he has to issue something to deliver a schedule of defects to the contractor, enlisting a set of all the defects that are in existence, and the contractor's job is then to make good the defects. Clause 15.4 imposes a duty on the architect to be responsible for the drawing up of the schedule of defects and deliver it to the contractor within the stipulated period of 14 days after the expiration of the defects liability period. Hence, the contractor need not notify nor remind the architect of this responsibility, but the architect has to monitor, initiate, and fulfill the requirement on his own. Notwithstanding this, it would still be preferable for the contractor to be proactive and to remind the letter should such an should such an eventuality not arise. So accordingly, clause 15.4 does not preclude the architect from delivering the schedule of defects to the contractor either beyond the stipulated 14-day period or a second one. And this cannot be considered to be waiver of the employer's rights. Alternatively, it also does not prohibit the architect from requesting for an extension of time for such delivery. So it tells you over here very briefly that the architect has a stipulated period of time for which he has to issue this document after the defects liability period. However, it does not preclude the architect, from delivering the schedule beyond the stipulated 14-day period or a second one. And in the event he does so, it cannot be considered to be a waiver of the employer's rights. Okay, and it certainly does not prohibit from requesting for an extension of time for such delivery. So sometimes you may need more than 14 days. The architect simply has to just request for additional time to issue the schedule of defects, because sometimes it can take extra time. 14 days may not be enough to actually identify and list all the defects. In such a case, you should get your architect to write to the contractor telling them that they need additional time to prepare the schedule of defects. So under clause 15.4, once the schedule has already been sent over to the contractor is obliged to make good the defects specified in the schedule of defects within a very short period of 28 days after receipt of the said schedule from the architect. To employers, of course, 28 days is a lot, but to a contractor, 28 days sometimes isn't sufficient if the defects or the schedule of defects contains too many items. So this is, of course, a serious issue that we have. But like I've said, under under clause 15, it's all so well drafted that it covers for all situations. You are allowed as an employer to give your contractor additional time over the 28-day period if you feel that he's able and capable of completing the job. It's just that he just requires additional time. So the time period for compliance starts running from the receipt of the schedule of defects from the architect. The day the contractor receives the schedule of defects, the 28 days starts to run. And the period for compliance is stated to be 28 days with a provision for it to be longer as may be agreed in writing by the architect. So as may be agreed in writing by the architect is the words used in the agreement, and ultimately this is the discretionary power of the architect to use, from which he has to assess on a case-to-case basis. The last part of clause 15.4 deals with the consequences of the contractor's failure to attend to the defects. And it also, of course, states the employer's remedies in such a situation. In clause 15.4, employer's remedies are stated as such, consequent to the contractor's failure to attend to the defects either satisfactorily or at all, or within the period prescribed by the architect, are confined merely to two principal ones, i.e. employment of third party or parties to rectify the defects or a diminution in value. So this is what we are talking about, two principles, which is employment of third party, which is your subsequent contractor, third party contractor, to rectify the defects or diminution of value. Both are usable remedies for the employer once the contractor's 28 days has lapsed. But ultimately you have to make a decision based on your facts as to which method you would rather use. The specified remedies are without prejudice to any other rights and remedies which the employer may possess under the contract. Okay, this is good because doesn't mean it means that you are allowed to have different types of rights and remedies. Just because you have exercised your right under clause 15.4, it doesn't mean that you are not entitled to exercise remedies under other parts of the contract. They may all be concurrently argued upon. Should a third party or parties is employed to rectify the defects, in such a case, it entitles the employer to set off all costs incurred, but subjects this to provision of clause 30.4. Remember, clause 15.4 shouldn't be looked at in isolation, because when we talk about setting off, you have to look at clause 30.4, because that actually tells you in what circumstances you can or cannot, and how to actually implement the setting of provision. So in the event the architect is of the opinion that it is either not feasible or desirable and that it would be preferable to leave the defects in the works, then he needs to consult the employer first and get his consent before he can implement his decision. Although the form of such consent is not stipulated, it can be implied that this should be expressed. This is again advisory to me. This is my advice rather. Uh, if you're going to, if your architect has made a decision, or rather has made a decision that there's no need for the defects to be rectified, but nonetheless we want diminution in value, please make sure that there's proper reasoning, documentation, letters between the architect and the employer that are all set. Because the last thing you want is when the dispute arises, the contractor says that there's collusion between the architect and the employer. That is, of course, a very, very serious allegation, but it is a very common allegation that is used by contractors when they see that the architect is simply just following the lead of the developer without actually using his own assessment skills. Rather, he's more like a mouthpiece to the employer. That should not be seen in any situation. So once the employer has consented, yeah, and clause 15.4 requires the architect to then instruct the contractor accordingly, and an appropriate deduction for such defects not made good by the contractor shall be set off by the employer. Just give me a second, yeah. Is it better now? Okay, sorry, I think the speaker was covered. Apologize. Sorry. So, yeah, clause 15.5 deals with defects which are required to be remedied. Sorry, I've already gone through this slide. So let me move to the next slide. Yeah, I apologize for that. I think the volume was shut out by the my holder over here. Now, clause 15.5 limits the defects to merely critical defects which need urgent rectification. Yeah, so this is a follow-up from the previous slide. The architect cannot simply just use clause 15.5 because, as you can see, it is requiring any critical defects, so which need urgent rectification. The way it has been worded, it can only be used in very limited circumstances. Cannot be used for every type of defect, but only critical defects which need urgent rectification. Yeah. This author, Mr. Harban Singh, in Engineering and Construction Contracts Management, the book, he said that urgent or emergency defects are defects which render the works liable to damage by the elements, will further deteriorate if not made good immediately, will impair the proper functioning and use of the works, or will critically deny the optimum operation and or beneficial use of the works. It's a very general description over here, but ultimately, critical defects would be something that you would have to assess from a case-to-case basis, or rather the architect would have to make that assessment. As for other defects that are not considered by the architect under clause 15.5 to be critical, needing an urgent rectification, he can take one of the two options available to him. First is he can wait until the end of the defect liability period and include this in the schedule of defects stipulated in clause 15.4, or the employer can exercise the remedies prescribed under clause 15.4, which is by diminution in value or by third-party action, which is to bring in a third-party contractor to rectify the works. However, this is something I want to highlight: the case of William Tompkinson and Son against Pastoral Church Council, which is a UK decision, but also referred to in Malaysian courts. In this case, the employer was not able to deduct all the costs incurred, especially for third-party action, but simply only what would have cost the contractor to make good the unreported defects. Yeah. So this is just for illustrative purposes to tell you that it is not usually cost of simply what would be all the works, but to make good only the unreported defects as well. In the event the architect does issue an architect's instruction, he would be obliged to give reasonable time for the contractor to comply with it. So since the defects in question are primarily due to contractor's breach of contract, clause 15.5 states that the contractor has to bear the costs incurred in the rectification process. That is very clear. The consequences of the contractor's failure to comply with the architect's instructions, the remedies available to the employer as a consequence of that, and the treatment of the cost entitlements, including the set-offs, are similar to clause 15.4. So what I want to actually just emphasize on over here is that the AI is obliged to give reasonable time for the contractor to comply with it. So reasonable time has not been defined, unlike when it comes to making good defects, it specifically states 28 days in the contract. Over here, under clause 15.5, when you use architect's instructions, then he's only obliged to give reasonable time, which is again something that is to be decided upon the discretion of the architect himself. Certificate of making good defects. Why is it an important certificate? Here are 7 reasons that we can consider. Firstly, it brings an end to the defect liability period in the contract. Second, it discharges any remaining entitlements or contractual rights of the contractor to enter the site and remedy the defects. Third, it terminates the contractor's obligations to the extent that they are concerned with performance to the architect's satisfaction. Fourth, it officially brings to an end the architect's power to issue instructions, or other architect's instructions. Fifth, if contractually required, the employer is to release the residual amount of any retention fund withheld. This is very important because once the certificate of making good defects is issued, it's essentially the architect telling the contractor that, look, you have satisfied all defects to a satisfactory level, and therefore it would trigger the second part of release of your retention fund monies, which is your second moiety in a lot of cases. So it's an important document because it gives the contractor his final walkaway monies. Sixth, it permits the architect to issue the penultimate certificate or the final certificate. And in the event there is no penultimate certificate, it requires the architect to issue the final certificate within a stipulated time. So remember, there is penultimate certificate, second last certificate, and the final certificate, which is the no further certificates to be issued once that is done. So it is really the tail end of the entire construction process. The certificate of making good defects, it would ultimately mean that both sides would usually have no further claims, no further disputes arising out of any matters. So that is ultimately the importance of the certificate. So how do we notify? Again, what is the notification provisions? Again, it is the contractor to notify and the architect to certify. Yeah, so the contractor notifies that he has made good all defects, and the architect then certifies, which means he has to make an assessment of whether the defects have been effectively made good or not. So under clause 15.6, under clause 15.6, the contractor shall give written notice to the architect as soon as he is of the opinion that all reported defects have been satisfactorily made good. The architect then can wait for the contractor's notification and is not obliged to initiate this stage of the defect notification process. Again, remember, it is the contractor's duty. It's not for the architect to be chasing for this kind of things. Contractor should always do this on his own volition. His failure to do so will only be to his loss. So again, time provision wise, the architect shall then within a maximum of 14 days, either if he agrees that there are no defects or the contractor has satisfactorily made good all the reported defects under clause 15.4, then he will issue a certificate of making good defects. He will also CC this to the employer and the nominated subcontractors. And the date of the said certificate shall be the date of receipt by the architect of the contractor's written notice under clause 15.6. If the reported defects have not been made good, this is the second part. So the contractor thinks he has done everything to a satisfactory stage, but the architect feels otherwise. So if the reported defects have not been made good at all, or presumably not made good satisfactorily, give written notice to the contractor with copies to the nominated subcontractors before expiry of the prescribed 14-day period of the rejection and the reasons for the rejection of the issuance of the certificate of making good defects. So same thing, you have 14 days to actually reject the contractor's proposal that he has made good all defects. You would actually have to give reasons. The architect will have to give reasons why you are saying these defects have not been made good, and you would issue reasons for this rejection, which is of course very important. Now, I will just end this with the review of certain court decisions. Yeah. Um, The first is the case of Ceylon Builders against Ultimate Pursuit in 2018. I want to, of course, I'm only sharing about 2 or 3 cases over here today, but it's all to do with the areas that I have covered. So in Ceylon Builders against Ultimate Pursuit, the claimant was appointed as the main contractor by the respondent with respect to the proposed construction subject to the agreement and conditions of PAM contract 2006 without quantities for a sum of 46 million ringgit. The claimant subsequently commenced adjudication under CIPA against the respondent to recover outstanding sums of monies due to him in the sum of around 1.3 million ringgit, and the adjudicator found in favor of the claimant. In an application later on by the claimant to enforce the adjudication decision as a judgment of the High Court, this is what happened. The respondent has filed an application to stay the adjudication decision, claiming that there are serious disputes in respect of the alleged defective works in the project which were not rectified by the claimant, and such dispute ought to be decided in the arbitration proceedings. So you can see over here, the party who objected, or rather was defending over here, had basically said that, meaning the contractor basically said that it's not fair for them to actually just deduct in the way or the manners in which they have done under the adjudication. This is something that should be fully ventilated at arbitration as to what are the so-called defects and whether they are even defects at all and how they have to be valued. So the High Court allowed the enforcement application and upheld the adjudication decision, which held that the schedule of which was issued beyond the time frame of within 14 days after the end of the DLP is not a schedule of defects issued for the purposes of clause 15.4 of the PAM contract. Therefore, technically, it is contractually invalid. In the premises, the claimant is not contractually bound to accept this said schedule. So here what has happened is defect liability period had ended, and the schedule of defects was not sent to the contractor within the 14-day period. Serious issue, obviously, because there was no extension of time that was obtained by the architect in this situation. So the adjudicator then rejected the respondent's claim against the claimant for the purported cost of 2 million over ringgit for making good the defects obtained from a third-party contractor, as the quotation was based on an invalid schedule of defects, which was found to not only be contractually invalid, but also inaccurate and misleading in terms of factual records. The quotation was found to be inaccurate and misleading as it had included items not listed even in the architect's latest schedule of defects dated September 2017 as defect items. So you see, firstly, the 14-day period importance is there. More important is the fact that you must actually have proper reasoning and documentation for anything that the architect states. So rejection, for example, of making good defects must be done so with proper and due reason. Now, in PCP construction against leap modulation, which is another decision of in 2018, this is what happened. Leap modulation appointed PCP construction as the main contractor for a commercial development via letter of award, and the contract was a PAM agreement. Disputes arose between the parties, and the architect issued a notice of default to PCP, and PCP was terminated through the particular notice of determination. PCP, of course, was not happy, so they commenced adjudication for claims or for losses that they have suffered arising out of the said termination. The adjudicator delivered his decision in favor of PCP, the contractor. PCP then applied to enforce the adjudication decision. On the other hand, of course, leap modulation applied to set aside and stay the adjudication decision. Now, leap modulation had agreed that the adjudicator had not acted impartially in allowing PCP's claim for usage and dismantling of the cranes and also for rental of the generator sets, but had failed to grant leap modulation's claim for rectification works and also for cost of completing the balance works. So you see here, both parties have their own respective claims. It's actually one party has a claim and the other has a counterclaim. But the main claim of leap modulation wasn't allowed. Instead, the main claim of PCP was allowed. So the High Court upheld the adjudication decision regarding the respondent's claim for rectification costs, where the adjudicator found that there was no evidence to support the claim as follows. And this is what he says, quote unquote, yeah. Even if I'm wrong with regard to the invalidity of the determination of the contract, the only apparent evidence before me in respect of rectification of the alleged defective and non-compliance works is an estimate by the quantity surveyor dated November 2017, tabulating the defects and the corresponding estimated costs. By this mere tabulation, the respondent has not proven the defective and non-compliance works. Even if the respondent had proven the existence of the same, the quantity surveyor's estimates do not demonstrate to me that the respondent has in fact incurred this amount or any part thereof. This is again very important because estimates not suffering the actual loss and all are points that the court will always look at. So it is not actually very advisable. Very often it is always should be backed up by actual losses. So no defects that could be said to be conclusively attributed to the claimant, and certainly no rectification works had been done or payments made to any third-party contractor for what had been tendered in evidence is merely a quotation. So just giving a quotation without actual proof of payment and so on would not assist your case. So this is something that I also wanted to share with all of you. I believe that brings an end to the session. So with that, I leave it to all of you to scan this QR code for feedback on my session. And once you all are done with it, I believe there is the assessment QR code. So I will, I think you can take over from here. And if there are any questions from the floor, I would be more than happy to assist to answer. Thank you.
Dear participants, so please scan this QR code for the questions and submit your answer within 10 minutes. Thank you. So while waiting for the participants to answer the assessment questions, we will proceed with the Q&A session for this webinar. So Mr. Ankit, there are a few questions posted in the chat box, and I will share the questions which has been posted. Langsung tak ada. So the first question is from Tiffany. She's asking that clause 30.4 of PAM contract requires the contractor to agree the set off or via adjudication before the employer is entitled to set off the amount incurred in rectifying defects or completing the works on behalf of the contractor. So as they're facing tight schedule in completing the project, and if they have served notice to the contractor to complete or rectify the works within a stipulated timeline, and the contractor fails to comply, is there any method where the employer is allowed to bring in third party to complete the works directly and set off without the original contractor's consent? And if yes, what are the steps to be taken by the employer?
I apologize. I understand that there's some questions asked, but I couldn't hear anything. So you could just give me a second.
Hi, Mr. Ankit, can you hear me? Hi, Ankit.
Sorry, can someone try to say something? I
Hi,
don't think
Mr.
I can hear
Ankit.
anything actually.
Can you hear me?
All right, I apologize, but I cannot hear anything coming from this side, from your side rather. Mayor is speaking, but I can't answer, or rather I can't hear a single voice actually anymore, although my volume is at full. So I apologize for this technical glitch again. I will just try and answer the questions that we have in the chat box here. So I think Tiffany has asked this question, clause 30.4. I won't read the question. I believe Mayor has already done that. So as we are facing tight schedule in completing the project, if we have served notice to the contractor to complete or rectify the works within a stipulated timeline and the contractor fails to comply, is there any method where the employer is allowed to bring in third party to complete the works directly and set off without the original contractor's consent? Uh, well, yes, technically you can. That's why under clause 15.2 or 15.3, if you remember under the second scenario, which I had given an illustration of, it is basically a situation where you have already given a certain period of time for the contractor to rectify, but he fails to properly rectify those works. Then what my advice would be is to issue at least one further letter, a subsequent letter informing them to state that they have failed to deliver their commitment to you within the projected 28-day period. The works are still defective and that you will have no choice but to bring in a third party contractor within 7 days from today. So you give them maybe an additional period of time of 7 days or 14 days. And if they do not, and if you still don't hear from them, I think it would be perfectly fine to actually bring in a third-party contractor to rectify this work. Of course, it would be without their original contractor's consent, but there is no choice when we deal with that. But ultimately, what you want is to make sure that you have built up your evidence such that if this becomes an issue later on, you can actually justify the reason for which you actually brought in the third-party contractors. It was something that was inevitable. That you had given a particular period of time. There was a lapse of period, and ultimately you had no choice but to bring in the third-party contractor. So it's very much it's a subjective test. It's a case-to-case basis, which it will have to be assessed. So ultimately, I think these decisions would need to be made by management, really from a perspective of how the project has been going, how has the contractor been performing, and so on and so forth. If the whole picture is in your favor, then yes, by all means, you would be entitled to actually bring in the third-party contractor to rectify the works, and you would be able to have a reasonable claim against the previous or the old original contractor for all those sums that you have had to fork out as additional payments, or you will be able to then set it off under clause 30.4 against sums that are due to the contractor, the old contractor, original contractor. Yep. So that is my answer to that question. Okay, is there any more questions?
So if there's no more questions, please scan the QR code on the screen to give the feedback. So I believe that's all the time we have today, and this marks the end of our webinar. Thank you very much for joining us.